Welcome to Rebel Chaser. My name is Gail, and I have several clips for you tonight. I've got one from Judge Mark Bronlich, child custody one. I've got one from Judge Devin Collier down in Florida. I've got one from Judge Gerald Prill in Michigan. I've got one from Judge Malicia Mogen in Wisconsin. And I've got one from Judge Stephen Warning in Washington. So, got several. They're all kind of different. The first few deal with attitude, just people having attitudes. And they seem to be taking it out on the court or other people. The last one is a custody issue, and it's two moms that just can't get along. So I'll let you guys watch.
Court is now in session. Add-on for Jolanda Spain versus Dwayne Wilkerson.
For the record, Dwayne Wilkerson has been elevated to this court from North Carolina Attorney Rebecca Hicks. This hearing this morning is being conducted via Zoom. Present is North Carolina Court Attorney Rebecca Hicks. Good morning, Ms. Hicks.
Morning, Your Honor.
And Mr. Dwayne Wilkerson, you are present on audio. Is that correct?
That's correct.
All right. Ms. Hicks, you're asking the court hold Mr. Wilkerson in contempt of court. Is that correct?
That is correct, Your Honor.
Can you provide a little background about Mr. Wilkerson's case?
Certainly, Your Honor. In this matter, there's a current monthly support obligation of $641 per month. The current arrears balance is $26,039.91. We received a $20 payment yesterday and two $10 payments in the month of February. That's all the payments we received after he made a $1,000 payment at the end of December so that his previous bench warrant would be pulled. He did claim today to Ms. Brower that he mailed a motion to modify support to the courthouse 2 weeks ago. But that's only, it's not been scanned in. There's no verification that one has been received. I do believe he stated that he mailed that in along with a fee waiver request.
Okay. All right. Has he been referred to the Attorney General's office? He should be charged with felony non-support. $26,000 in arrears, Mr. Wilkerson. You are lucky you're not being charged with a felony criminal charge of non-support. You go to prison for that. In any event, of course, if you're charged with that, you can go to prison. The most this court can do is 45 days in jail. So do you understand, Mr. Wilkerson, you're being charged this morning with civil contempt of court for failure to pay child support. The maximum sentence being 45 days in jail. Since there's possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all that?
Yes, I do.
Are you asking for a court-appointed attorney?
I mean, I don't understand what's going on. You saying that I'm facing jail time?
Mr. Wilkerson, yes, you're moving closer and closer to jail later this week. So do you want an attorney?
Oh yeah, of course I'll take an attorney.
All right. The court's going to order that you personally appear. I need to ask you a few questions to qualify you for a court-appointed attorney. Are you currently employed?
No, I'm not.
How do you support yourself?
I do odds and odd jobs here. I sewer snakes and all of that stuff. Backup drains here in Detroit.
Okay. So you are employed, but were you self-employed?
Well, basically self-employed. It's like you get paid on the table when someone calls you if they got a backup or something. Unfortunately,
Okay.
Being here, it's so much competition, so it's not like it's every day.
So you're a self-employed plumber, is that correct?
No, I'm not a plumber. You don't need to have a plumbing license to snake someone's main drain.
Okay, so you're in the sewer business.
Well, no, I wouldn't say I'm in the sewer business. This is what I do to make some money.
Okay. Well, you need
Clean
to
out basements.
Right. So, how much you take home per week, average?
I don't know. It's about $450. Sometimes $700. I don't know. It's just hard to tell. And that's not consistent at all.
Do you own any property of any value, such as an automobile or bank accounts?
Well, no, I don't.
All right.
And my house is in somebody else's name. It's not just my house. It's owned by another person as well.
All right. Court will grant your request for court-appointed attorney.
Appreciate it.
Mr. Wilkerson, the court's I'm going to give you a couple days to get some money together. I'm going to order you personally appear before this court on Friday.
Well, I'm not going to get any money together. How am I going to get any money together? I can't even get a ride to work. I'd have suspended license.
Okay. Mr. Wilkerson.
And I never had that before. But I want you to know, sir, that I take care of my kids' clothes, haircuts, phones. I just bought a $200 phone the other day from the little money that I did make. So we're not going to get it misconstrued. And I understand that, yes, I have an obligation here, but I have been trying to pay. Okay?
Mr.
I'm not running away from nothing.
Mr. Wilkerson, when you're done talking, let me know and I can talk.
Oh, I'm not trying to talk over you. I thought I was able to talk. I apologize. Sorry about that.
Okay. If in fact you are buying all these things for the children, then you have Miss Spain come down and waive some of these arrearages. You have no obligation to buy cell phones for the children or pay for the haircuts. You need to pay child support through the Monroe County Friendly Court. That's what the court order says. So that what you can do to help yourself, I'm offering you a suggestion to have Miss Spain come down and waive some of these arrearages. That's going to help you. The court's going to order you personally appear. Mr. Wilkerson, the court's ordering you personally appear on Friday this week. That's March 8th, 2024, 11:15 a.m. And the court's going to order you to bring $1,000 or a toothbrush. I'm suggesting that, Mr. Wilkerson.
Well, I'm gonna bring the toothbrush. I can tell you that right now, sir. I don't have enough $1,000 to give you, so I'll bring my toothbrush. I'll be ready to go Friday.
Okay, 11:15 a.m.
So what time you say I got to appear? What time you say I got to appear Friday?
County Courthouse.
What time?
11:15 a.m. We'll get you over there before lunch.
I'll be there. Thank you a lot, sir. Appreciate you.
You're welcome.
Threaten me with jail. Is that all for me?
Yes. Let me get a cell number for you because I'm gonna have the court-appointed lawyer talk with you ahead of time. So give me a cell number they can reach you at.
Yeah, 313-986.
So, Mr. Wilkerson, I'd rather you stay out working. You need to get a more steady job. If you can come up with $1,000, the court's inclined to.
I don't have another $1,000. I got other personal problems. I don't have another $1,000. I'll see you Fridays. Am I done?
Okay. Yes, you're all set. I'll see you on Friday, 11:15.
You're not going to threaten me, sir. I'll see you Friday.
Okay.
Are you done with me?
Yes, you can zoom out, Mr. Wilkerson.
See you later.
Brian Cathcart. Mr. Cathcart before you in a misdemeanor case number 23-108. This is one that was reassigned to you from Judge McFarland's docket. It's a violation of probation arraignment on a simple battery charge. If found guilty of the violation, Mr. Cathcart could receive a sentence of up to 1 year in jail. At this time, I'd enter in denial on Mr. Cathcart's behalf and request that he come back next month. I'm still waiting on an offer to resolve the case from the state.
I got one, Mr.
Oh, sorry. That's okay.
Or bring it back, sorry.
Judge, I just received an offer in this case. It's to admit that he violated his probation. The sentence would be 270 days in jail. He would receive credit for any time that he spent in jail previously. There would be a $150 VOP fee, and his probation would be revoked. Mr. Cathcart, I know I just got this and just had time to announce it on the record here, but if you were to admit that you violated your probation, the judge would sentence you to a county jail sentence of 270 days. You would receive jail credit for any time that you have already spent in jail on this case. Your probation would be revoked and you would be assessed a $150 VOP fee. You do not have to accept this offer. If you accept it today, the judge will impose that sentence. If you deny the VOP, then your case will be set for an evidentiary hearing at a later date.
Yeah, okay, I accept it. Don't give a shit. Don't give a...
Here, watch your language, sir. Sign right there.
Stupid.
Hey, whoa. Mr. Cathcart,
Yes, sir.
you used some swear language, and Mr. Hill told you to watch your language.
My bad.
And then look at me. And then after Mr. Hill told you to use your language, you cursed again. Where do you think you are?
In court for some
If you-
BS.
If you're in court, why don't you act like it?
I am acting like it. It's just,
No, you're not. You don't curse in my courtroom. I don't curse at you. You're not going to curse in my courtroom. You hear me?
not cursing at you.
You're cursing in my courtroom.
All right, my bad.
My bad. That's what you say on the streets, okay? I'm sorry.
I'm sorry.
You want to go forward with this plea?
Yeah.
Yes, sir.
Yes, sir.
I'm not your friend, Mr. Cathcart, okay?
Not your friend.
All right. Well, this is what we're going to do, Mr. Cathcart. I'm not accepting this plea deal. We'll see you next month. When you learn how to behave yourself properly in the courtroom, then we can talk about you accepting the plea deal, all right? If you want to keep acting that way, I'll hold you in contempt and throw you in the county jail for a year. Come back here. Did you hear what I said?
Yes, sir.
If you don't know how to conduct yourself in the courtroom, that's fine. There's consequences for that. You can end up in the county jail for a year, okay, sir?
Okay.
I'm gonna respect you. You're gonna respect this process, all right, Mr. Cathcart?
Yes, sir.
I understand that you don't want to be here, that you think the charges or the violation may not be legitimate, but you have to conduct yourself as an adult, all right?
All right.
I'll see you next month, and that will be on April 25th at 1:30.
All right.
Wilfred Apley versus Tiffany Glaza, 216908 DP. Mr. Apley's motion regarding custody, parenting time, and other matters. He is in the courtroom. He's in pro se. Ms. Glaza appears in the courtroom via Zoom. Will both parties please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Ms. Glaza, will you raise your right hand? Did you hear the oath?
Yes, I did.
And you promise to tell the truth?
Yes.
Thank you. Ms. Schultz, what's the current custodial rate?
Your Honor, on November 29th of 2022, an order entered granting the parties joint legal and joint physical custody with equal custodial time on a week-to-week basis year-round, as well as alternate holidays pursuant to the 2016 Friend of the Court Parenting Time Guidelines. Ms. Glaza was to exercise her overnight visitation at the home of her parents in Alton, Michigan.
Thank you. Mr. Apley, what is your motion? What are you asking for?
Full custody or at least temporary custody
Based on
of our child. Based on she got based on her history but she just was arrested with my child.
the child was in the vehicle?
The child was in the vehicle, yes, while she got arrested and caught with drugs. I don't know if you want me to elaborate on anything more, but
What alleged controlled substances are being thrown out there?
I believe meth and cocaine, crack cocaine.
Ms. Glaza, I have to caution you. Obviously, there are pending criminal charges out there, so I'm going to remind you have the right to, relative to any criminal allegations, you have the right to remain silent. Your silence cannot be used against you. However, if you do testify in this matter, you're under oath, and whatever you state in this courtroom can be used potentially in your criminal proceeding. Do you understand that?
Yes.
Okay. How do you respond to this at this time?
I have not yet been found guilty of anything, Your Honor.
Okay.
And I know what I've done wrong. And I'm taking the blame for that. But I have not been found guilty in a court of law. And I don't believe that our arrangements should be changed at all.
All right. Thank you. There must be a showing of either proper cause or change in circumstance. Court finds a change in circumstance. The defendant was arrested in this matter, or not in this matter. She was arrested relative to criminal allegations of controlled substances. The information provided by father, which is uncontroverted at this time, uncontroverted, indicates that the child was in the vehicle. On an interim basis, the court is going to order that Mr. Apley shall have sole legal, sole physical custody of the minor child. While the defendant is incarcerated, any parenting time is suspended. If she is released from the county jail, she can file a motion to address parenting time. This is an interim order, and so it's not a permanent order. And the court will also order that with having interim sole legal, sole physical, the child cannot be removed from the state without prior approval of the court, nor more than 100 miles from the child's current address. Anything else?
Is the court also ordering that child support be abated effective February 23rd, 2024?
Yes. And
I can't hear anything you guys are saying.
Oh, the support is going to be abated. There will be no support that'll be owing from you at this point, as you are currently incarcerated. And the court is also going to order a friend of the court investigation regarding custody, parenting time, and support.
Okay.
Is the court ordering an investigation prior to release, or how does the court wish us to address that?
I just wanted to start now. Just to start it now, so we don't delay things. Because eventually the criminal charges will be moving forward wherever they're going. I don't know where they're going, we'll find out. Do you have anything else to show?
Just to clarify, currently Mr. Apley is the payer of child support. So it is his obligation that's being abated.
Oh, I'm sorry.
Stopped. But we will address support in accordance with the custody and parenting.
Yes, thank you. Appreciate it. You're all set, folks. Thank you.
Can you look, did he prepay $500?
I only had a cash bond of 200.
Yeah, going back to January 11th, it was to prepay 500 total, 200 for the restitution and 300 for the balance of the costs.
Let me see, maybe something's in another fund that I didn't.
Well, Mr. Thayer, did you prepay the remaining of that $500?
No, I was told to only pay 200.
No, you weren't, because we were in a hearing and I told you that thing again, and you said, I thought I only had to pay 200. I said, no,
Because I
you
talked to my
don't.
lawyer, you know what I mean, before I called the clerk of courts.
You know what I mean? This was the same conversation we had on January 11th with your lawyer too. And your lawyer said, I'm sorry, Judge, I only told him 200. And I said, yep, but that was wrong. So it's 500. This was January 11th. We had this exact conversation.
I'd like to make a record too, Judge, because I did take the blame for that. I thought just the restitution had to be paid up front. You explicitly told myself and my client, no, he needs to pay the entire amount. I believe that Jeremy was in court for that, and I was too. So I don't want the court to think that I told him that after that hearing that he only had to pay 200.
I don't believe that is the case, Mr. Davis, because I was very clear on January 11th, very clear that 500 needed to be paid. And then we said, okay, Mr. Thayer, when can you get the additional 300? And then I pushed it out to here because he said he needed a couple months.
Yeah, we actually did this twice. We did it once on January 11th and once on February 7th, and all conversations were identical.
So we're going to reset it. We'll go on the record in the matter 23 CM 102, 23 CT 72, 23 CT 90, State of Wisconsin versus Jeremy Thayer. The state appears through District Attorney James Renicky in person. We have Nicholas Davis, who's appearing by video. We have Jeremy Thayer appearing by video in custody at Polk County Jail. Apparently he's on a probation hold. We're set here today in this matter for a plea and sentencing. The court inquired into whether or not the full $500 has been prepaid as required. It has not. Mr. Thayer was again confused about his need to pay the full $500 before having a plea and sentencing. We had a hearing on January 11th
in which this matter was discussed, as well as February 7th, in which this matter was discussed, where it was sentenced for a plea in sentencing. The court provided additional time for Mr. Thayer to get $300 more. Mr. Thayer, are you in any way confused about the requirement before the plea and sentencing can occur?
No, not now, Your Honor. You know, I understand that. I was
So
supposed
you're on
to
a
pay it.
PO hold. Do you know when your PO hold runs?
I'm not sure. I just did my statement and everything yesterday because Amber didn't have time to come down there, so she had somebody in Polk do it for me.
So are you looking at being revoked?
No, not that I know of, no.
All right, so when do you think you can get this $300 paid?
Well, I got my next paycheck comes on my card, so I can do it within the next 2 weeks.
All right, so let's get this scheduled again so that we can get it taken care of, because I don't know if you have other open charges, or I don't know what it's happening, but I'm going to tell you it's in your best interest to get these resolved before you get any other charges, or Mr. Renicky could charge bail jumps or something.
Okay.
Mr. Thayer and Mr. Davis, can you do a plea and sentencing anytime on April 2nd, 3rd, 4th, or 5th?
Yes, I can do it on the second. I can. What time on the second would you like, Your Honor?
How about 1 o'clock?
Yes, Your Honor, I can do that.
April 2nd, 1 o'clock. Mr. Thayer, have the $300 prepaid.
Yes.
And I believe that he is pleading to,
Misdemeanor criminal damage to property.
all right, okay, so we can't do it by stipulation. So have the $300 paid by that date and time, and this will go without a hitch, okay?
Okay.
All right, thank you. We are adjourned.
And I see Ms. Gill, so let's go back to the Johnston matter.
Sorry about that. I had to rejoin, I have to leave it and rejoin.
No problem.
So, Your Honor, we were going to request a set over. I was just appointed. The case is quite voluminous, so I haven't had a chance to go over it. Additionally, in reviewing the orders, my client's at the point where she can now petition the court to transition the child home. And so that is the motion that we need to file. So my thought was set it over to give her time to do that, so then we can come back to court and start discussing a plan to transition home.
Let me ask the question, Ms. Gill, from your standpoint, how are the visits going?
Not well since November. And in my understanding, she's not allowed to petition the court until we are in phase 4 or doing phase 4. But things were going really well up until November. Her and I were working together. I even petitioned to get her overnight visits months before she would have originally been allowed. When November hit, Gage was introduced to the third man since December 2022 as a new boyfriend. She then started taking him to overnight visits at the boyfriend's house out of town, where she will not disclose the address to me or allow me to pick him up from. And
Your Honor, we're going to object. That's not true. She has the address.
All right, everybody hang on. Ms. Gill, go ahead and finish.
All right. So only up until I was given paperwork from the Superior Court did I know the address. It was accidentally put on a piece of paper. She still has not allowed me to pick him up or know where this address is out of town. But for months, she had been still claiming to me she was living at the Oxford house and doing overnight visits there and having me pick him up from a house she was not actually living at or staying at with Gage. The issues I have with him, where she's residing, one, not knowing where. Two, it's with a boyfriend that has just been released from prison within the last few months. And there's 2 other men living in this house, Gage has told me, that I do not know. A man named Tuff and his dad. There is no bedroom for Gage. He's been sleeping in her bedroom, which I don't think is right, especially if she's wanting to have more overnight visits with him. And Gage has been coming home more aggressive because he's been being taught how to box. The aggression at school has increased and behaviors to the point where the teachers have called me multiple times to ask if something else has changed outside of our home to cause the increase of aggression and behaviors. And not just with that, but he's coming home and saying that he's not allowed to call me his parent anymore, which he's called me his parent since of age 4, that he is only allowed to call me his aunt because this is all my fault that he's not with his mom, and that he's not my kid, he's her kid. And these types of things should not be discussed to a child at this age, nor a child that is already struggling with regulating his emotions at that regard. So we have had such a low level of communication because of all this and all these, secrets, whereas before she was so transparent about everything.
Your Honor. Hang on. All right, Ms. Jocelyn?
Yes, so this is one of the things, I haven't been able to get into this, and unfortunately what Ms. Gill is saying is just simply convenient at us wanting to reach out and move to phase 4. I called Ms. Gill 3 times, no response. I emailed her. She finally emailed me back on Monday. This is the first time that myself or my client has heard of this. It's just convenient that after we're talking about restructuring phase 4, that all of a sudden she's freaking out and saying all these things are happening. My client and her had a discussion about potentially changing phase 4, which is why I reached out to Ms. Gill. And then after the 3rd time of reaching out, when she finally responded, and I have emails, we can send it to the court, she's like, no, that's not the agreement. So this is part of the reason why we need to have a set over. I need to get a clear understanding of what's going on. Nothing, Ms. Gill has filed no declaration stating any of this. My client has no chance to respond. She's made no complaints. She's made no motions before the court to change anything. It's time we move into phase 4. My client's going to petition to have the child transitioned. And I understand my client is very thankful for Ms. Gill. And we understand that my client and Ms. Gill have been together for a long time. And unfortunately, part of this is Ms. Gill is upset and having the child is transitioning back. My client has no desire to cut Ms. Gill out. And once he transitions back, still wants her to have time, whether it's every other weekend or a weekend. So my client, unfortunately, with having me just retained, having no information before the court, she can't properly defend herself when nothing that's been said is in any documents. So that's why we're requesting a set over. And then we were going to also file a motion to modify phase 4 because that's not, from our position, not the most appropriate thing for phase 4. So I think a set over of a month would be appropriate to give us time to do that. And then if Ms. Gill has anything she wants to file, she can file it in the appropriate time frame. So my client gets a chance to address it and not have it sprung on her.
Okay, here's what we're gonna do. I will put the matter to April the 4th at 10:30. I'll put at the end of the calendar because there may be a necessity for some testimony. In the meantime, Ms. Johnson, the visits take place at your home, period, end of conversation. Ms. Gill always knows exactly where that child is at any time. Is that understood?
Yes, Your Honor. I live with my significant other, and I told her.
Okay, Ms. Gill or Ms. Johnson, hang on. Whoever else is in that house, you need to make sure Ms. Jocelyn has all that information. You need to make sure Ms. Gill has that information.
Absolutely.
What's going on with UAs since you're not in the Oxford house?
I just did a hair follicle. Unfortunately, I had it done and I had it sent to all parties. I did forget to file the copy with the courts. I did file it this morning. I apologize for that. I've been gathering all this information, trying to get it with my attorney. So I'm a CDL driver. So between my work schedule and getting everything from my attorney, I did forget to do that, but I did it this morning. I've been clean for 29 months. I've got a career now. I'm doing everything. My son is thriving under my care. Like,
ma'am, hang on.
It's Your Honor, to make it easier, she filed Miss Gill and I got a copy of the hair directly from Omega Laboratories. She took a hair follicle on 2/22. That was filed today, Your Honor. It is negative for amphetamines, meth, coke, opiates, phencyclidine, and THC. My client also has a multitude of UAs that I'm in the process of gathering. I wanted to file it all at once under seal so the court had the total so we didn't have to go back. But for example, one UA I'm looking at right now from 1/18 of this year, again, negative for everything that was screened for.
Okay.
And so,
Your Honor, I have a question about the drug tests also. So in our original parenting plan, it states that I can request any type of drug test and I have to pay for it ahead of time, right? And that if she's negative, she has to reimburse me, which she never has. And if it's negative, I pay it, excuse me. If it's positive, she has to reimburse me. But in September, when we went to court, she asked for it to be changed. And
Okay,
for
so what's
her,
your question?
so my question is back in September, if it was modified, because she asked for it to be modified, that she'd be willing to pay for any tests I request, because I don't ever really request them. And the judge in September said that they don't normally do that, but because we were working so well together and he didn't think I'd take advantage of it, that he would put that in the order that she would pay if I requested it. Well, I requested a hair follicle on the 2nd of February, and she refused unless I paid for it,
Okay,
stating she never said that.
Everybody hang on. Okay, the order says respondent shall UA hair follicle upon request at her expense and must provide a follicle test before review for phase 4 in 6 months. So that's still the order. And if somebody owes somebody, that needs to be taken care of.
Your Honor, I think what she's asking is that was a one-time, that was not saying moving forward. So my client did pay for the hair follicle and that's what she filed today.
All right, well, this one doesn't say one time only. It just says upon request.
The judge said,
okay, I'm getting tired of getting interrupted.
I'm sorry.
The secret.
It says upon request. If there has been just one request in 6 months, it's not being taken advantage of. And from Ms. Johnson's standpoint, a current one would probably be a brilliant idea for that hearing in a month. Pending that hearing in a month, Ms. Gill knows exactly where the child is staying at all times. She knows who's in that house. She's entitled to go visit the house if she wants. She's not going to be a regular guest there, but she's entitled to know exactly what's going on. I'm not going to have anybody hiding anything. Everybody understand that?
Yes, Your Honor.
Your Honor.
All right. So April the 4th, and it would also be a good idea from both sides' standpoint to provide some sort of pleadings and affidavit showing where things stand now. So whoever's hearing this has an idea what the issues may be.
May I make a request, Your Honor?
Yes, ma'am.
Yeah, I was wondering if we could do pickups and drop-offs at the local DSHS office, the CPS office. That way there's less conflict. There's been.
If you guys can't get along for the pickup and drop off, I want to know about that. Everybody gets to behave like an adult, and anybody who can't, that tells me an awful lot.
That's been part of our issue recently is she keeps attacking me during pickups and drop-offs.
Did you hear what I just said? If anybody can't behave like an adult, that's important information for whoever's hearing this.
Okay.
All right, the 4th at 10:30.
Perfect. And I'll work with the parties about pickup and drop off, Your Honor, and try to smooth anything out.
All right. Thank you, counsel.
Thank you.
Thank you.
Thank you guys for watching. I know it was kind of a quick night, went pretty fast, but thank you. I really do appreciate you all being here, and I'll see you next time.